Hi, Ms. Cofer.
Hello.
My name is Larissa Olivia. I'm one of the prosecutors on the case, okay? I just have a couple questions for you. Were you personally the victim of any crime?
Not in over 30 years.
In over 30 years, and you were living in Satilla Shores for how long?
Since 1976.
Okay, so since then, you're not personally a victim of any crime, right?
Well, since 1976 I was, but it's been more than 30 years ago
Okay,
that I was a victim of any crime.
okay. Do you believe that someone stealing is deserving of death penalty, Mr.
Objection to
Cofer?
relevance, Your Honor.
I'll withdraw the question, Judge.
We've got a motion to make at this point.
I mean,
Finish the examination of the witness.
we're done.
That's all I have for Ms. Cofer. Thank you.
And you can go ahead and sit down. I'm sorry, I'm going to
No, thank
You can go ahead and sit down. Thank you, ma'am. You can go ahead and step down. Is she subject to recall?
She is not subject to recall.
Thank you, ma'am. You are excused. All right. Ladies and gentlemen, we're to get breaking point for lunch. We will, let's recess for an hour. We'll plan to get back to the evidence at 12:45. Again, during the recess, do not discuss this case amongst yourselves. Enjoy your lunch, and we'll see you in an hour. Thank you.
It's all right for the jury. Please be seated.
Your Honor, I have a motion. Thank you. I would ask the court, on behalf of Greg McMichael, that the jury be brought back in after lunch, that in front of the jury, Ms. Olivier be admonished for asking a question that she knew or certainly ought to have known was impermissible, as was clear by the fact that she made no attempt to defend it. And number two, that the jury be instructed to disregard that question and whatever feelings it might have made them have. And I will state for the record, because we don't have daily reports coming out, that the question was, do you believe that someone stealing is deserving of the death penalty? It's inappropriate, it's incendiary, it's prejudicial, it's improper, and we ask that she be sanctioned in front of the jury for having done that in any case, but in such a serious case.
We join.
Your Honor, I'd join in that motion, and if I can have the lunch recess to confer with counsel without waiving the issue, I don't understand why we're not moving why there wasn't a motion for a mistrial. I don't know how you cure that, but given all the time that we've put into this trial, and I'm talking about everybody in the judicial system, before making that motion, if the court will allow me, I'd like to have the lunch break to confer. Maybe there's something I'm missing here, that's not the appropriate thing to ask for. But if I have to do it now or lose it, then I'm going to move for a mistrial.
How about this? You've reserved it.
Thank you, Your Honor.
And state before we recess.
Just note for the record that Juror 12 paid attention fully, was totally engaged, and absolutely no issues with Juror 12 during this period.
Watching Juror 12, and that accurately reflects the court's observations of Juror number 12 also during the...
Your Honor, I'm having trouble hearing you.
That accurately reflects the court's observations of Juror number 12 during the second half of the morning's proceedings. All right, we are in recess for an hour. I will take the matter under advisement. At some point, I would like to hear from the state on that question. Maybe we'll do it when we come back after lunch.
Your Honor, without pushing the court, I would ask that if the court wishes to hear from the state, from the prosecutor who made that remark, that she be asked to respond to it now, just as we needed to provide this request at the moment that it happened and contemporaneous with the error.
Fair enough. Anything from the state?
Your Honor, I'm not sure what you're asking. Ms. Hill.
Why you asked that question?
That the question, what do you believe someone who steals is subject to the death penalty?
Yes, Your Honor. I believed it was an appropriate question for Ms. Kofer, given that I had her on cross-examination. I thought it was an appropriate question.
Matters under advisement. We are in recess.
Okay, some fireworks to finish the session this morning in Brunswick, Georgia. Robert Sanders is with us. Robert, that question, all three defense attorneys were quick to jump up. Was it an appropriate question? She defended it. The prosecutor did. Your thoughts?
She's on cross-examination. That witness was there to elicit information about crime in the neighborhood. Her questions were about crime in the neighborhood. Now, the defense failed to get from the witness what they wanted to get, but they put her on the stand and they made her open for cross. Was that question so out of the area of which she was testifying that it was inappropriate? I think that's a fine line. And if the judge believes that it doesn't fit into what was that witness was offered for, he's going to admonish that counsel and have her stand up and hear in front of the judge and the jury that it was inappropriate. But this is a fine line. That witness was brought on to talk about crime. The question was about crime.
But the question was obviously a statement on some level. The judge doesn't have to
Sure,
admonish her.
certainly.
Could he also just have a curative an instruction to disregard?
Sure, he could do exactly that, which is to say, that statement or that question that was asked by the prosecution, whatever problem he sees with it, state that, and then ask the jurors to take what appropriate action he deems, ignore the statement, ignore the question, and move on from there. But if crime is the reason the witness was brought on board and the statement was about crime, it may fit.
Let's talk about Travis McMichael. He took the stand over 2 days. Yesterday afternoon, beginning with direct in the beginning of cross, and then it finished this morning. It was riveting at times. Your overall thoughts on how Linda Donikowski did for the state of Georgia and how the defendant did in trying to defend his actions on that day that he took Ahmaud Arbery's life?
Well, first about the defendant. He tried to stay to the script. Unfortunately for him, a lot of the statements that he made on the stand were not the statements that he made contemporaneous with the events in which he killed Ahmaud Arbery. And that allowed the prosecution to say, well, eventually, were you lying then and telling us the truth at the time you killed him, or were you not? Or are you lying now? When you've had time to reflect, had time to be coached by counsel and understand what answers you can give that will be helpful to you and what answers that you can give that will be harmful to you. The point about activities in front of the truck and his truck after he got out of it, and whether or not he had the shotgun leveled at Mr. Arbery or whether it was up, as he said, in a salute position across his chest in a diagonal pose. What happened when the examiner got on and the question that was asked by the prosecution about how that weapon was positioned, it made it clear that he was not speaking the truth about how he had that weapon positioned. And when you heard that tape, the shot was fired before they came out from behind the car. So if he had that weapon up, as he says he did, in those seconds, that shot wouldn't have hit Ahmaud Arbery, and it did.
Yeah.
So the problem
it absolutely did.
has been raised, and she has given, the prosecutor, gave him a chance to walk his way out of it. He walked his way into it.
Yeah, and he was, he was on the stand long enough for the jury to really get a feel for all of it. Robert Sanders, I want to thank you for your time and expertise this morning. We really appreciate it. We're live, of course, in Wisconsin, Kenosha, where the jury continues to deliberate the fate of Kyle Rittenhouse. We'll talk about that and much more as Court TV Live rolls on at the top of the hour. Julie Grant will be here taking over. Stay with us. Be right back.